All right, I think we'll get started. Good morning, good afternoon, good evening, everyone. Welcome to all of our guests, wherever you may be in the world. My name is Melissa Tirani, and I'm a partner at Gowling WLG's Montreal office and a member of the Advertising and Product Regulatory Group. I am delighted to welcome you all to the next and 12th installment in our webinar series, The Lifecycle of a Smart Idea, where in previous sessions, we would have discussed a strategy for developing a global brand. Today, we're going to be addressing the many ways in which infringing parties can impact the control of that brand online, including by registering domain names, creating social media accounts, and even masquerading as a brand owner online. So in order to highlight the strategies that brand owners may use and to protect and enforce their rights, I'm going to be playing the role of the Global General Counsel for a Canadian-based ATV company known as Hellranger Inc. But before we begin, please allow me to introduce you to today's panel. So first up, we have Eric Macramala, a partner in our Ottawa office and a member of the firm's IP group. He's also a legal analyst for TSN. We've got Zoe Pierman, an IP associate in our Birmingham, UK office. Clémence Lapotre, who is a principal associate in our Paris office, specializing in IP and information technology. We have Alexander Dovgaluk, a litigation and enforcement lawyer in our Moscow office with more than 12 years of experience in IP enforcement and litigation. We've got Jalene Kwek, a senior associate and lawyer in Singapore, specializing in trademark portfolio management and enforcement. And last but not least, we have Laurent, a legal director in our Guangzhou office and leader of the non-contentious team in China. So the objective of today's webinar is to really canvass the critical issues surrounding online brand protection and enforcement globally. But if you have any questions or if there are strategies or recommendations you'd like to discuss further, we invite you to please join our panelists in the virtual breakout rooms that will begin right after the webinar. So there you'll really get a chance to see and speak to the panelists directly and even to engage in discussions with some of the other attendees. So as I mentioned, for this webinar, I'm going to be playing the role of the global GC at Hellranger, which is a Canadian-based company that recently began selling Hellranger branded boots and beverages in 6 key markets, those being North America, Canada, the US, the UK, Europe, Russia, Singapore, and China. So thanks to previous advice from Gowling, we did obtain trademark and design registrations for all of those brands, which you can see on screen. But I was recently advised by my marketing team that a third party or potentially third parties has started to impersonate our company and brand online, which, as you can imagine, is particularly worrisome at present since online sales is really the sole source of revenue right now for us, as governments continue to impose lockdowns and restrictions on non-essential business. So now more than ever, as COVID-19 continues to accelerate the growth of e-commerce, we really need to protect those platforms and our brand online. It's absolutely critical. So while our team continues to delve into what's going on, I have requested a meeting with our external legal team at Gowlings, as I do have a meeting with our CEO this week to discuss our enforcement options and the next steps. So as you'll see on the screen, as part of their deception, these third parties have been relentless. They've published website content containing infringing Hellranger trademarks. They've created social media accounts across numerous jurisdictions. They've gone so far as to even register multiple domain names and to even pay for sponsored link ads. So the objective of today's meeting is going to be to explore the causes of actions and the strategical steps that I, as the brand, may take in each of these jurisdictions. So let's begin with what we consider to be the most pressing matter, the fact that this infringing party has published website content with our trademarks, our design marks, which, to make matters worse, are directing traffic to their unauthorized Amazon, eBay, and Alibaba e-commerce platforms. So Zoe, perhaps you could begin with an outline of our options to address this issue in the UK.
In the UK, this would bring you into the realm of civil enforcement of your IP rights against the infringer directly. So our first step would be to identify the infringer if that's not already known. Identification can be difficult as the registrar and the e-commerce platforms can be reluctant to disclose such information without a court order, so it may require you instructing investigators or applying to court. Once identified, we recommend you first send a letter before action to the infringer, but this would not apply in circumstances of extreme urgency, such as an injunction, where you would apply to the court immediately. If there's no traction through correspondence with the infringer, you'll have to consider whether to commence infringement proceedings. We can rely on trademark infringement here, providing that the use is within the course of trade. But as the infringer is directing traffic directly to its Amazon and eBay account, then this will likely be satisfied. But if it is a hurdle, then copyright may be an option for you in the UK. It's not registrable and comes into being on creation. Where the infringer has used your copyrighted images, then you can rely on copyright. And we have recently successfully got an injunction based on website content that infringed our client's copyright. There may also be some options around criminal prosecution, depending on the infringement.
Okay, so I'm not sure if this is purely coincidental or whether it's a result of the infringing party's English websites directing to their Amazon and eBay accounts, but we have seen a significant decline in online sales in the UK specifically. So what immediate action could I take to take those down, and how quickly could we expect a resolution?
So the e-commerce platforms would be dealt with separately in the UK. Firstly, we would want to establish if the goods being sold were counterfeit or if they infringed your rights. If so, we would utilise the specific takedown procedures that are available on Amazon and eBay. The forms are relatively prescriptive and do not let you provide a lot of information. So where infringement is complicated, or if we need to rely on an unregistered right, we would also recommend writing to the platform itself with further details. Where it's a clear infringement, the platforms can take the listings down relatively quickly, but if it's complicated, it may take a little bit longer, but it's still much quicker than court proceedings. However, if the goods being sold by the infringer are legitimate, we would need to consider whether or not your rights could be said to be exhausted. This would occur when the goods have been placed on the market with your consent in either the UK or the EEA. However, it's worth noting that going forwards, goods placed on the UK market may no longer be considered exhausted in EEA post-Brexit.
Okay, so that's an excellent point. It's unclear right now, and we're still investigating whether the products that are sold on these websites are counterfeit or gray market. So we might need to consider both possibilities. Clémence, is the process in France and Europe more broadly similar in most respects to the UK approach?
Yes, indeed, Melissa. The process in both EU and France shares numerous similarities with the UK. However, there are three recommendations that I would like to make here. Firstly, as a preliminary step, I would advise securing evidence of the litigious online content to be able to provide them to court should we need to go that far. So this is something that can be done simply through screenshots. However, their validity can be challenged before courts. Therefore, I would recommend asking a bailiff to draft a report on each litigious website or page to officially establish the display and the offer for sale of infringing goods in France and Europe. It should be noted that the fact that the litigious content can be accessed from France is displayed in French, among other languages, and that the goods can be delivered in France can suffice to trigger French courts' jurisdiction. However, its extent will notably depend on the infringer's location. Secondly, as Zoe mentioned, Herwanger, on the basis of its IP rights, can use the specific takedowns procedures available on Amazon, Alibaba, and eBay. So as hosting providers, this platform must respond and react diligently. In this respect, it should be noted that the Draft Service Act, which is an EU act, will further strengthen the obligation of marketplaces to fight against illegal content and thus enable a rapid and effective response, which is crucial in our case. In the event of complex matters, I would also recommend sending a separate written notification to this platform. In any case, what we need to know is that such process will result in the takedown of the litigious offers for sale and eventually sanctions against the infringers, but only from the concerned platform. So finally, if Herwanger is willing to obtain additional remedies, it will be required to bring a court action. So what is particularly interesting here is that if Herwanger holds European rights, we will be able to go to the competent EU court and obtain pan-European injunctions to see the litigious acts, to destroy the infringing goods, and to pay financial damages, for instance. If not, to obtain similar remedies, we will have to bring an action in each member state on the basis of national rights. We can choose, for instance, to go before French courts that are known as IP rights friendly, or before German courts, for instance, whose procedures are recognized for their rapidity. So, there is a lot of option, and we'll be happy to give more details on this topic in the breakout room session that will take place later.
Thanks, Clémence. So it looks like we do have quite a few options in France. Turning to Russia now, Alex, do the takedown measures or civil recourses differ in Russia?
Well, in general, takedown measures and civil recourses are similar in Russia. But in case the website content is not removed after takedown requests or after direct demand letter to the infringer, I would suggest that we take a closer look to the unfair competition action rather than a civil action. Unfair competition cases in Russia are heard by the Federal Anti-Monopoly Service and its local branches. Unfair competition is a very broad definition, which includes various kinds of infringements, such as actions causing confusion, which is trademark infringement, and passing off copyright infringement and misrepresentation. In other words, every action that the infringer commits on our infringing website. The unfair competition proceedings are administrative proceedings, which means that they are rather public than a private action. Remedies resulting from successful proceedings before FAS take the form of an order addressed to the infringer to cease the infringement. FAS also imposes a fine on the infringer, and I can say that usually infringers tend to comply very quickly with FAS orders, and this option, so not very quick, but can be considered as quite effective to go against website infringements. This is a long story, and if you want to discuss this in more detail, you can join me in a breakout room session after this webinar.
Thank you. So it sounds like unfair competition proceedings before the Federal Anti-Monopoly Service would be the most advisable to get the infringing party to cease and desist from using our trademarks on their site. Laurent, what rights would I need to take these websites down in China?
Yes, you surely have actions to take in China. They are quite similar to what can be done in other jurisdictions, i.e. complaints with the website and court actions. Most e-commerce platforms in China have its IP right complaint mechanism, like Alibaba, Taobao, Tmall. These are 3 different websites, but they all belong to Alibaba Group. So they have the shared IP complaint mechanism. Other popular Chinese e-commerce platforms such as JD.com, VIP, Kaola, etc. They also have complaint channels. Concretely, what our IP enforcement team in China would do is we will firstly conduct internet monitoring on major e-commerce platforms, helping the brand or product owners like Hellranger to identify the infringing links on the e-commerce platform. Once suspicious links are found, they will be able to make complaints on behalf of the client and take down the infringing links. I have invited my colleague Sophia Liu to join me in the breakout room so we can discuss later on. Sophia is a senior associate based in China. She's specialized in IP enforcement. So do join us in the breakout room. Although actions to take are quite similar in most jurisdictions, I do want to draw your attention on the following. The Chinese e-commerce law coming into effectiveness on 1st January 2019 gives e-platforms the ability to recover the infringing links should no administrative or court actions are taken by the brand owners within 15 days since the links are taken down. Therefore, should Hellranger wants to do a complete cleanup job, it shall ultimately commence court or administrative actions such as AMR or customs seizure actions. We do not really recommend filing an unfair competition case if a trademark infringement case could be filed, because provisions of the Chinese unfair competition law is pretty vague, and therefore it's quite hard to navigate a case. That's it for China. And Jarlene, what's your position in Singapore?
For Singapore, we can seek an interim injunction to stop the infringing use, which may be granted if the balance of convenience lies in favor of granting the injunction. If there is no arguable defense to the claims at issue, we can even obtain summary judgment. Hell Ranger's trademark registrations can form the basis for initiating the infringement suit. Its trading activities can also give rise to common law rights, which also can be a basis. Lastly, we may also argue that Hell Ranger's trademark is a well-known mark in Singapore. So which basis we choose to take will really depend on Hell Ranger's activities in Singapore. Prima facie, on the facts, since the third party appears to be impersonating the company and brand online, we can possibly argue that a counterfeit trademark is being used. So Hell Ranger will be able to get additional damages if we succeed on this basis. The consequences of counterfeiting a trademark in Singapore are also serious, and this can be mentioned in a demand letter to the infringer before we decide to take action. Just to highlight a few other points, there can be trademark use even if the trademark has not been seen by anyone in Singapore. So this can counter a possible defense that the infringing website has not been viewed by anyone. Trademark use in Singapore is also rather widely construed. There can be use of the infringing sign on any commercial document, including any such document in any medium, or even using the sign in advertising. So on the topic of trademark use, I was once told that trademark use in advertising does not constitute trademark infringement in Canada. I will turn this over to Eric to clarify.
Thank you, and happy to be here talking with you. Even happier to learn that I didn't sell all of my suits. Look, I've been doing this since Al Gore invented the internet, and every case is different, and they all follow along a spectrum. And the first question we always ask is, before we take any action, is how much harm is being inflicted on the business? How much harm is being inflicted on the brand owner, and in this case, Hell Ranger? And based upon that answer, then we take the appropriate action. If the website you've identified, the third-party website infringing Hell Ranger's rights, is inflicting that harm, that you want to get that site down as soon as possible. And if that site's misappropriated copyrighted works, which we presume will be the case in trademarks, then you can issue a letter to the hosting company and knock that site down. Once you knock the site down, that could help assist in bringing this to a premature end. If that site resolves to online marketplaces, Amazon, eBay, Lazada, Alibaba, I mean, the list is endless, then you have to deal with each of those marketplaces. Again, you assess, are these sites a big deal? Because the whole goal here is to move as efficiently and cost effectively as you possibly can. But taking the site down, I think, is really important if you can do that in the first instance. And then you ask yourself, how else are they misappropriating IP with a view to extracting a financial gain by piggybacking on your trademark rights via social media, using the domain names, sponsored link advertisements? It has to be a holistic assessment. Take the site down. But if you feel like this site is a huge, huge issue and you can establish jurisdiction over that potential defendant, then another option is to file a court action and to get that interim relief to pull that site down. And so you have a lot of options available to you with respect to addressing the harm being inflicted on you and the brand. The key issue here, and this is the same respect to any action you take, is making sure you pick the right course of action. And that's going to mean efficiency and cost.
Thanks, Eric. And some of these websites in numerous jurisdictions are definitely critical right now. They're affecting our brand. My understanding is that website takedown measures are far more expeditious and efficient than domain name transfers, which is why I did want to tackle that first. But I still do want to address the multiple domain names that were being registered globally. So not only do all of the infringing domain names include the Hell Ranger brand, some also include disparaging content within the domain name itself. So there's one that's Hell Ranger sucks, I believe. Obviously, it's unclear at this time whether all the domain names in issue are being registered by the same or multiple parties, but I did want to address both the disparaging ones and the top level domain names that were registered. So there's a .store, there's a .shop. There are also high level or top level country code domain names such as .com, .ca, .co.uk, etc. So you get the gist. These bad actors are really relentless, and they're going after seemingly all of our key global markets. So, I mean, Eric, since you have home court advantage, perhaps you could outline what our options might be to address these issues in Canada and in the US.
You know, thanks, Melissa. Across my 22 years practicing at Gowling, this is where I started. My statement of claim, when I sue someone, it's really changed. 22 years ago, it was just a sign up at a place of business. It's like, hey, take the sign down. Now it's a website, online marketplaces, social media, domain names, sponsored links. So there's a lot going on. And in my experience, you're seeing these infringing parties utilize each of these different instruments with a view to extracting financial gain. With respect to the specific question related to domain names, I mean, my goodness, I mean, there are so many top level domains. Melissa mentioned .com, .net, there's .org, .info, .biz, .cc for Cocos Islands, which has become a generic top level domain. You've got your country codes, .ca for Canada, .de for Germany, .jp for Japan, .com, .cn for China, on and on and on. And then you have 1,200 new domain name extensions, 1,200. .shop, .store, .xyz, .contractor, on and on and on. And so if you have an infringing party that has used it, has misappropriated your trademark in the domain name, so that's the second level domain name, the part before the .com, the part before the .de, then you ask yourself, do we take action against the domain name? Now, if it's a situation where this party is just going crazy and misappropriating all of your IP, I don't know if the best course of action is to go after the domain name exclusively. The way you would do that is filing a UDRP complaint for .com, .net, .org, info, and then a lot of the country codes either submit to the UDRP or have their own local dispute resolution policies. If it's just a domain name, you can do that, but if it's part of a larger matrix of infringement, then maybe you wrap it up in a statement of claim or in the US in a complaint or other jurisdictions and you sue the person. But you have options available to you when it comes to domain names. I mentioned the UDRP, local dispute resolution policies. On top of that, you could always sue. The US has the ACPA, the Anti-Cyber Squad and Consumer Protection Act, which was inserted into the Lanham Act, the US trademark legislation that allows parties, plaintiffs, to address unauthorized domain name registrations executed in bad faith. The reason the ACPA can be a pretty compelling piece of legislation is because it provides for punitive damages of $100,000 per domain name in the instance where someone is a serial cyber squatter or has engaged in really naughty behavior. And that's important because you don't need to have a domain name owner who lives in the US or a plaintiff who resides in the US to use the ACPA, because the ACPA contemplates non-US parties using that legislation to go after domain names. So it can be an important tool to extract leverage, but it's pretty expensive. But ultimately, when it comes to domain names, you have a number of different options available to you. And again, it comes down to, let's make sure we pick the right option.
Certainly. And so, Zoe, what actions might be available in the UK? I do like the options that Eric just mentioned in the US, but what's available in the UK?
So in the UK, if we were looking to take down the .co.uk domain names, there are kind of three main steps that you would take. Your first step would be to submit a complaint to the registrar and ask them to deactivate the account. In some previous matters, we have seen the registrar comply, but we will probably face some pushback. But if we can enter into a dialogue with them, we can see what progress can be made. And then if this was successful, it would allow for relatively cheap and cost-effective resolution. Our second step would be to write to the infringer if they can be identified, but following GDPR, it can be quite difficult to identify the infringer in the UK, as much of the publicly available information has been redacted for privacy purposes. As Eric mentioned, when there's a serial infringer, it's good to, kind of take a focused attack on them rather than just singling out one domain name, because in the long term, going against the infringer can be much more effective. Whereas if you just go after one domain name, they can take it down and simply re-register it with another registrar. And then your final option, if neither of these succeed, or if you can't identify the infringer, you would follow the Nominet dispute resolution procedure. Nominet is the official registry for .uk domain names. Similarities with the UDRP policy that Eric mentioned. You would first have to show that you have rights which are enforceable in the UK, which are identical or similar to the infringing domains, and that the domain name counts as an abusive registration. For example, we could say that because the domain name has been used to confuse users, that would be an abusive registration. But it is specifically stated that where a domain name is not used, where it's purely being used, sorry, for criticism, it's not an abuse of registration. So we may have less success under Nominet against the Hell Ranger Sucks domain name. And just one final thing I'd like to flag is that we will need to consider whether you remain eligible for .eu domain names following Brexit. This is a bit different, and it's something that I would be happy to give more details about in the breakout rooms.
Thanks, Zoe. So turning to France now, Clémence, can I compel the transfer of the .fr and the .eu domain names in Europe?
Yes, Melissa, you can, but if you have identified the domain name and it's older. So as Zoe mentioned, usually infringers do not identify themselves, and GDPR rules now enable owners of a domain name to redact their identity and contact details on privacy grounds. Therefore, if the investigations conducted online are unsuccessful, I recommend directly requesting the lifting of anonymity and obtain the personal details of the domain name holders, either from the URID for .eu domain names or from the AFNIC for .fr domain names. So this can be done by filing a form explaining why we need the holders' contact details and how we tend to use them. Once we have obtained such details, we will be able to proceed. We will proceed with a complaint, either before the checked arbitration court, which is in charge of the alternative dispute resolution procedure for all domain names under .eu, or following the CRD procedure managed by the AFNIC for domain names under .fr. To succeed, we will be required to meet similar requirements, meaning first, to show that Hell Ranger holds prior right to the domain name, such as trademark or trade name or company name rights. And second, that the current holder of the litigious domain name uses them for, or use it or them for abusive purposes, such as promoting and offering infringing goods. But in any case, a successful procedure, as we discussed it, will exclusively result in the transfer or the removal of the domain names. And as mentioned earlier, Hell Ranger will have to consider complementary diligences to obtain additional remedies, such as interim proceedings or an action on the merits.
Merci, Clémence. I don't believe Russia offers an ADR process. Is that currently the case, Alex? And if that is the case, what concrete options do we have allowed to shut down the .ru domain names? Or alternatively, to have them transferred to us?
Yes, that is the case. There are no UDRP similar alternative domain name resolution policies available for trademark owners in Russia in respect of Russian country code top-level domain names, such as RU, SU, and RF in Cyrillic. This means that the only way for a trademark owner to obtain an infringing domain name, unless, of course, the registrant assigns it voluntarily, is by way of a trademark infringement civil action. Like in the UK and France, the first step in any domain name infringement case would be to identify the infringer, which is usually the registrant. The vast majority of registrants are individuals, and their identity is hidden behind a privacy shield. However, unlike the UK and France, registrars cannot deny a trademark owner's request for disclosure of the registrant identity based on Gdpr. And in most cases, registrars provide such information. And if the information on the registrant is correct, and it's true, then the trademark owner can proceed with a civil action, which is very good for trademark owners. Russian courts usually grant interim reliefs in respect of infringing domain name and block any operations with it during the litigation. For example, they prohibit termination of the domain name registration or its assignment to any third party. This means that as soon as that court action is filed and the interim injunction is granted, it is usually granted in one business day. Well, the transfer of the domain name to the trademark owner is almost 100% guaranteed. And as soon as the court decision comes into force, the domain name registration is terminated and the trademark owner gets a 30-day grace period to register the domain name in its own name. Well, that's it for Russia. Jalin, perhaps you could speak to the situation in Singapore and the approach company could take in China.
Thank you, Alex. So contrary to Russia, we are encouraged to use alternative dispute resolution to try to resolve the domain name dispute. We can file an administrative action with the SDRP Secretariat, which is managed by the Singapore Mediation Centre. The dispute will then be conducted via mediation to afford parties an opportunity to resolve the dispute via mediation, failing which the panel will decide the dispute. If any party is dissatisfied with the panel's decision, the aggrieved party can apply to the court for the dispute to be decided instead. Just wanted to highlight that as a preventative measure, it is advisable to register at least a GTLD or a .sg domain. So to assist registrants in this regard, SGNIC and IPOS have a collaboration to provide a service to reserve a .sg domain name for free when the trademark patent or design is filed in Singapore. So if you wish to know more about the domain name reservation service, do join me in the breakout room after this. That's all for Singapore. I'll pass it on to Lerong.
Yeah, thank you, darling. For China, over general top-level domain names such like .com, .net can be submitted to CEATEC and Hong Kong IAC for arbitration. CEATEC and Hong Kong IAC are the two of the four centers nominated by the Asian Domain Name Dispute Resolution Center. So the other two centers are in Kuala Lumpur and Seoul. But the relevant disputes resolution procedure is pretty much in line with the ones in every other jurisdiction because they're under UDRP. But for .cn websites, the dispute could either be submitted to CEATEC or Hong Kong IAC again. So the rules overlooking the procedure is called CNDRP, issued by China Internet Network Information Center. CNDRP is not too much different from UDRP, but one important remark to make is that under CNDRP, if a website exists more than 3 years, the dispute over this domain name cannot be subject to this dispute resolution procedure anymore. So parties shall file the complaint at court. Also, one last point about the particularity for .cn domain name, because I hear from my colleagues in Europe and UK mention that due to the privacy laws, it might not be easy to identify the domain name owner. Just want to flag that for .cn, it's comparatively easy for us to locate an infringing domain name owner because we have this ICP, Internet Content Provider Recordal and Approval Procedure for .cn websites. And this ICP procedure would give the website a registration or approval number. And using this number, you will be able to identify the owner through the snake website. And if you find a .cn website, especially the website has commercial purpose without displaying the ICP information, you could directly report this website to the MIIT, which is Ministry of Industry Information Technology, and the website will be blocked if ICP procedure have not been carried out. That's the position for China.
Okay, thank you. So if I understand correctly, the common thread among all jurisdictions is a need to firstly identify the domain name cyber squatter, with identification being somewhat more difficult in the UK and Europe because of GDPR privacy laws. So we may need to engage PIs in certain jurisdictions, I guess, depending on how much difficulty we encounter. And then most jurisdictions offer two potential angles of attack. We've got the ability to file a domain name dispute resolution complaint with the official registrar or via the UDRP, since of course we are the legitimate trademark owner and the infringing party is clearly in bad faith and an abusive registrant. And then the other option, which is really the only option in certain jurisdictions, is instituting legal proceedings for either trademark infringement or unfair competition. So the next issue I'd like to address are the social media accounts that were created. And these were created on Facebook, on Twitter, Instagram, TikTok, pretty much all of the main social media platforms. And what it looks like is that they're using these social media accounts to really capitalize on our brand's online presence during COVID. And that's also kind of legitimizing and lending credibility to their unauthorized websites. and marketplace platforms. So Eric, how can I shut these accounts down in Canada and the US, and how quickly can we do this?
So first, just really quickly, you got a question that came in about trying to effectively enforce rights against in somewhat elusive potential defendants, someone located far in the far reaches of our world. And I can't answer that now, but I can do that in the breakout room. So if you have questions about how to assert jurisdiction against these various pieces of intangible intellectual property and how we can grab that and shut it down, I'm happy to do so. One of those are social media accounts. When you have a third party who is engaging in infringing activities, looking to extract a financial benefit off your IP, 9 out of 10 times, if not 10 out of 10 times, sometimes 11 out of 10 times, you got to look to Facebook, Instagram, and Twitter, especially using Instagram and Facebook with a view to promoting those goods or services. So if there's a site, try and find out if they have images on Instagram and if they have a Facebook account. And in those instances, what you want to be doing is, if you identify infringing content, is file a complaint with Facebook or a complaint with Instagram, owned by the same company, obviously, file one with Twitter, whatever social media platforms you're seeing this outfit is on, with a view to having the account taken down. Just a couple of quick practical notes. Twitter is effectively a First Amendment website, so it is really hard to get accounts terminated, even in situations where the infringement is like a law school exam question, like you can't miss it. And sometimes they'll say, well, no, we don't think that's the case. So you refile with Twitter, and sometimes it'll come down the second time, third time, or fourth time. Other thing is, if there's copyrighted content on the social media account, like on Twitter or Facebook, but the account itself is creating the overall commercial impression that they're affiliated with a brand owner, don't file a copyright complaint. Each of these platforms have different complaints: copyright, impersonation, trademark infringement. So if you file a copyright complaint, all Facebook will do or Twitter will do is pluck the copyrighted work from the account. Now, once you pluck that, your argument that the overall commercial impression is that it's affiliated with a brand owner now becomes weaker. So yeah, this is yet another example. Make sure you pick the right policy when you're looking to tear them down.
Okay, that makes a lot of sense. The other issue that we're grappling with is there's a French account, and it's a French from France account, not a Canadian French account, that is essentially masquerading as the CEO and brand owner. And so what we have is there's a posting there with our CEO's picture and her name. And so obviously she's super alarmed and worried about this. Clémence, what action could we take in France to shut down that social media account? And this is on Instagram.
Yes, Melissa, in France and Europe, I would consider two main actions. So the first step, as Eric mentioned, is to proceed with a takedown request on the social network. However, since we have discussed that at length, there is a second option that can also be considered here, which is based on the Gdpr and which may go further. So as a matter of fact, the name and the picture of LWLG's CEO qualify as personal data protected by the Gdpr. And in particular, Article 17 of the Gdpr provides a right to be forgotten that enables any individual to demand that a search engine remove certain results linked to his or her name and surname from search results. And this makes it possible, if the account is not deactivated by the social network, to prevent any internet user from accessing the litigious content, here the profile, through a search engine. And I think, this can be considered as a powerful option.
That's really interesting because, I mean, the proposed amendments to Quebec's privacy laws also propose to include a right to be forgotten. So that might be an avenue we could take here as well, if that happens. My marketing team is also telling me that an account was created on a prominent Russian social media platform, which is driving a lot of traffic to their e-commerce site. Alex, what is the takedown process for this platform? And I apologize, I don't remember the name.
No, it's okay. This is VK, which was created by Pavel Durov, which you might have heard of. He now owns Telegram. Well, like many other social media platforms, VK developed complaint resolution policy aimed at blocking infringing content, which includes content infringing intellectual property rights. This policy works very well. VK already granted some of our clients' requests and blocked infringing groups offering counterfeit products for sale. However, VK requires that right holders provide documents confirming the infringement, documents confirming the right holder's title, and usually they always require a power of attorney, and sometimes they require that this power of attorney, which allows us to represent the client before VK, is notarized in the country of origin and even affixed with apostille, so that it is 100% legal and correct. Any failure to meet formal requirements of VK may result in dismissal of the takedown request. However, if the formal requirements are met, VK is very quick to remove, and the infringement is clear, VK is very quickly to remove the infringing content and can even block the whole infringing group.
Okay, that's really encouraging. Laurent, I understand that China has its very own version of Facebook. Are there other social media platforms we should be looking into in Asia? Because we might have missed some. And what would the takedown process consist of?
Yes, Melissa, you're right. Chinese have our own version of social media. We have WeChat, which is more of a powerful WhatsApp, allowing us not only communicating with contacts, but sharing photos and live, but also as a very great payment tool, etc. And we also have Weibo, which is more like Twitter, and Douyin, which is the Chinese version of TikTok. So these social platforms generally do not have any e-commerce functions. So if the accounts of this social media want the viewers to buy any products, they will direct the customers to a website or an e-commerce platform. WeChat offers a portal to a e-commerce platform called Weidian, but WeChat confirms to us that Weidian is run by it's different from WeChat. Therefore, the actions we take on the social media accounts infringing Hellranger's trademark and copyright product catalog images. They might not be able to sell directly the infringed products. With the social media, the very first step is still make the complaint with social media. Besides, the brand owner can go straight to court. In China, we now have internet call only in Beijing, Hangzhou, and Guangzhou, where our China office is based. This is a new first instance court, and the court is able to hear cases arising from the internet. Disputes arising from social media accounts are definitely covered. So cases like domain name disputes, infringement of copyright or trademark on the internet or on the social media account, they can all hear that. And all court procedure of this internet call is carried out online, and the aim is to improve the efficiency of court proceedings. Obviously, if you want your case being heard in this court, the dispute should have some connections with the three cities that I just mentioned. For example, the place of computers or servers containing the infringing materials, or the place of the defendants, etc. Otherwise, the case will still need to be brought to the usual first instance court. One last thing to mention is the possibility of creating a fake Hellranger corporate social media account on the Chinese social media is quite difficult. Taking WeChat as an example, if you want to create a corporate account on WeChat, you will need to provide the relevant business license. So you have to provide a Hellranger business license. And especially when the corporate account is linked to a brand or some products, WeChat usually will ask the applicant to provide a relevant trademark registration certificate or at least a trademark license agreement.
Okay,
that's China.
Thank you. So that's all been very helpful. I am mindful of time, but the last issue I was hoping to address were these sponsored link Google ads. So as you can imagine, these are misdirecting significant traffic to the cyber spotters marketplace. And I suspect that's why we're seeing a significant decline in sales in North America and Asia. I know there is a distinction to be made between when the trademark appears in the actual text of the ad or simply is to trigger the ad, but I was wondering whether that distinction is relevant in all jurisdictions. Eric, perhaps you could speak to the US and Canada, and then Jialing and Laurent, who could quickly speak to Asia.
Okay, I'm no longer muted. So this is an important issue for brand owners, and within this scenario or just generally, get this question all the time. Bottom line is this: you have to ask yourself, is your trademark visible in the text of the ad? If it is not, if your trademark is simply being used as a keyword to trigger the sponsored link advertisement, well, your two options are go to Google or go to the infringing party. If you go to Google, they'll tell you get lost. It's only being used as a keyword, it doesn't appear in the ad. If you go to the brand owner and they get good legal advice, they'll tell you to get lost because it doesn't appear in the visible text of the ad. Okay, so to summarize, they'll tell you to get lost. If the trademark appears in the visible text of the ad, for the most part, you can go to Google and they will terminate the ad, except save in situations where they are of the view that it's the fair use of a trademark. For example, in the context of comparative advertising, but it has to be clear in comparative advertising. You could also take it up with the infringing party. Once again, it turns on the likelihood of confusion. That's what the courts are going to assess in Canada and in the US. This has become abundantly clear. There's been a lot of litigation in the US across all the circuit courts, some litigation in Canada, and ultimately the question you ask, when the trademark is visible in the text of the sponsored link ad, is it likely to confuse end users as to source of sponsorship? On the technical kind of boring side of the trademark side is that if you have a trademark registration for services, well, it's use of your trademark in an advertisement. So if your mark is registered with services and it appears in the visible text of the ad, you have a really good argument that's infringement because use of a trademark for services occurs in the ad. So, and then if your registration is for goods, you have to be able to convince the court that, look, when the end user clicks on the ad and they make a purchase, they're confused as to source of sponsorship. Not an easy argument. All that aside, done lots of these. Whether your trademark appears is being used as a keyword or appears in the visible text of the ad, send a letter to the infringing party, because 99 out of 100 times, they don't want to deal with this headache and they will discontinue the use of the keyword. But from a legal standpoint, that's your distinction, Melissa, visible versus non-visible.
Okay, and I know Clémence has a ton of experience with Google Ads and AdSense, so perhaps we can discuss that further in the virtual breakout room. Jialing and Laurent, very quickly, what is the case in Asia? In China, I know these are appearing on Baidu, which is the Google equivalent in China.
Okay, so for Singapore, the courts here have not yet discussed the issue of trademark infringement in relation to sponsored link advertisements, but my personal view is that these would most likely not qualify as infringement, because the issue with sponsored link advertisements is that these usually only create initial interest confusion, and this doctrine has been rejected by the courts in Singapore for practical reasons. Specifically, the Court of Appeal did note in a case that confusion which arose in the initial stages of the purchasing process but was dispelled by the time of purchase did not constitute confusion.
Yeah, for China, Melissa, you're right. We don't use Google. We use Baidu. So we want to, but we cannot. So the same as other jurisdictions, Hellranger could start by filing a complaint with Baidu. They may or may not take down the link as per your request because they do not have the capability nor the power to decide whether there is an infringement there or not. So ultimately, Hellranger, if this is discovered that someone is using this Hellranger as a keyword, as sponsored link advertisement, they will need to go pursue legal action. If an infringer only pays for Baidu to direct the customers entering Hellranger in the search box to their own link, but on their own link, there is no Hellranger trademark there at all. It is really hard. Under Chinese law, it's really hard to establish a trademark infringement. Confusion or misidentification itself is not sufficient. In China, commercial use is often the most important criteria to decide whether there is an infringement. So where there is only confusion but no commercial use of the trademark, Hellranger could file an unfair competition case instead.
Okay, so it appears that there's no real clear consensus among all jurisdictions. So I think we have a pretty good sense of what our plan of attack should be and which infringement actions we should prioritize. Now, switching out of my fictional role as GC, I'd like to thank all of our panelists as well as our attendees for joining us. We hope you found the webinar both entertaining and informative. I'd also like to invite you to join our panelists in the virtual breakout rooms. The link is in the chat, and you can kind of bounce in and out of the different rooms. They're separated based on jurisdiction. And also, please keep an eye out for the next webinar in the series, which will be all about artificial intelligence. We hope to see you again soon. Thank you, and take care, everyone.